Hi, everybody. As I can see, folks are starting to trickle in now. My numbers are moving. I'll start us formally here in about another minute. So thank you for attending. It's kind of fun on my end. I get to watch all of these numbers tick up. I feel like I should play the lottery or something. It's like a slot machine.
It's a little bit like an impeachment vote. And unfortunately, they might all be yeses. I'm not sure. So watching the numbers tick up make me nervous, Tamara.
Okay. It's always good to have the other perspective. And I know we'll have folks that'll probably trickle in and out given teaching schedules, and that is totally fine. Please feel free as you are joining to leave if you have to. We totally understand. And many of us are still getting used to the whole time difference. Some of us who don't do daylight savings time and others who do. Just gonna wait one more minute. All right, I think our numbers have stabilized enough that it's safe for me to kick us off. And I just want to say a huge welcome. Thank you. Welcome to ASU Law. That's hard to say. ASU Law's inaugural Judy Stinson Lecture. We're so happy and excited that you're able to join us today. For those who don't know me and can't read my name, that might be small on your screen. I'm Tamara Herrera. I'm one of the associate deans and a legal writing professor here at ASU Law. How this will work is I'm going to introduce our dean here, who will say a few words about this lecture, and Judy Stinson, and then Judy will introduce our speaker, who is Linda Berger, professor of Law Emerita from UNLV, and she'll be talking on Justice Sotomayor's Rhetoric of Settings. As most webinars work, as you're sure, I will come back at the end and take any questions that you might have in the time we have remaining. We're set to go for an hour. So please type your questions into the Q&A box and I'll read those to Linda when we get to the end. So now it's my pleasure to introduce our dean, Doug Sylvester. Thank you for joining us, Doug.
Well, I'm happy to be here, Tamara. Thanks for allowing me to speak. Few will ever let me do it twice, so I really appreciate that. Welcome, everybody. I really just wanted to say on behalf of the whole law school, thank you all for being here today to help us really kick off this event and honor really the legacy of Judy Stinson. Welcome to the Judy Stinson Memorial Lecture, even though I think you're still alive, Judy. I don't know. You're dead to me. You're retired. That's all I know. It is a real honor. When people came to me and asked whether this was something we could put together, this was one of the easiest decisions I'd ever had to say, oh my God, how can we find a way to honor Judy and all that she's given to the law school and to this particular profession? What a great idea. It was really driven by Tamara and the writing faculty, our amazing writing faculty currently here at ASU, and hi Kirsten and others who have left and gone to other places. It's just wonderful to see everybody here. So again, welcome to our annual event, the Judy Stinson Lecture. This is really an honor of Judy. If anybody doesn't know her, I don't know why you're here. Judy taught legal writing for 27 years. So we hired Judy when you were 11. She has managed to put in enough service hours to retire at the age of 35. So congratulations, Judy. It's fantastic. In addition to her spectacular career in writing, I just want to make sure everybody knows what she's meant to this law school. It is unequivocal that this law school would be out of business and currently in receivership to Arizona Summit School of Law if Judy hadn't been here running the ship, quite frankly, for the last 11 years. I owe her everything in my own job. I would have clearly had a heart attack or a stroke of some kind within a few months if it hadn't been for Judy's unbelievably tireless passion, dedication, and extraordinary skill at administration in keeping this law school moving forward. She is in almost every possible way the progenitor of this writing program at ASU, of which we are extraordinarily proud. It is so focused on our faculty and our students. It manages to continue to have a huge impact on our students every single day. And it has to do again with the vision and passion and humanity that Judy has brought to every single part of this law school. I think if I could really just cap off why we wanted to honor, I think it really is that word. And that's the one that we don't often associate with associate deans for 5 to 7 years, is humanity. No one associates that with me. And so it has really been just our honor to really say, thank you, Judy, for what you've done for this law school. I thank you personally for everything you've done for me. You are an incredible human, an incredible scholar, an amazing administrator, and I look forward to being part of this process for the next 27 years when we can celebrate your 60th birthday, I think is what it'll be in 27 years. It's going to be fantastic. So thank you all for being here. Linda, thank you for agreeing to do this first lecture, a spectacular choice on behalf of Judy and everybody. And so to our staff, to all of you, thanks for being here. And Judy, thank you for being, oh, I don't know, Judy. So I'm going to hand it off to you, and you're going to introduce Linda, and I'm going to do what deans do, and I'm probably going to have to step out of here in just a couple of minutes, but Judy, it's off to you. We love you.
Thank you, Doug. I'm very honored by this event. I would like to thank first the Sandra Day O'Connor College of Law at Arizona State University, especially Dean Sylvester. The law school has always been supportive, and Dean Sylvester's been incredibly supportive of legal writing and transformed what we do here at the law school. I'd also like to thank Professor Tamara Herrera. I believe this lecture series was her brainchild, and I know she's using some of her WPK fellowship money for this event. And she's obviously done a lot of administrative work to make this happen. So very much appreciate that, along with Professors Alyssa Dragnich and Kim Holst, who've spent a lot of time working on the lecture's logistics and communication. Thank you all for that. I'd also like to thank my colleagues, first at the College of Law. All of you have been incredibly supportive over the last 24 years, and especially my legal methods colleagues. I can't imagine working with a better group of people, and I mean that genuinely from the bottom of my heart. I have been very, very fortunate. And colleagues nationally. There are too many to include, but my career was greatly influenced by a number of people, a large number of people, and that's one of the best parts of teaching legal writing. The field is full of helpful, generous mentors and lifelong friends. Finally, I'd like to thank Professor Linda Berger for giving this inaugural lecture and for being the role model and mentor that she is. She's made a significant difference in my career, and I know there are a whole lot of people who can say that. So thank you, Linda, for making this so memorable. So with that, it is my great pleasure to introduce Professor Linda Berger. She's, as Tamara mentioned, Professor of Law Emerita at UNLV, William S. Boyd School of Law. And from her bio, her research and writing and teaching until recently converge on the study and practice of legal rhetoric, drawing on cognitive psychology as well as on composition, rhetoric, metaphor, analogy, and narrative theory. She served as president of the Legal Writing Institute, an organization with 2,000 members. I had the pleasure of working with Linda when she served on the board of directors of the Association of Legal Writing Directors, ALWID. Professor Berger has authored numerous books and book chapters and dozens of scholarly articles, as well as founded a key law journal, Legal Communication and Rhetoric, J. ALWID. Professor Berger is a recognized leader in transforming legal writing as an academic discipline, so much so that our field's top scholarly award was created in her honor. The Linda Berger Award for Excellence in Legal Writing Scholarship is ALWID's highest award recognizing scholarship in the field of legal writing. ALWID created this award in 2016 to recognize the profound impact that Linda Berger has had on the discipline of legal writing through her scholarly work, as well as her support of both emerging and established scholars in the field. Throughout my career, I've always enjoyed her writing and her presentations. I know they'll be engaging, and I'll learn a lot, and I'm sure we all will today. Please join me in welcoming Professor Linda Berger.
Thank you, Judy. I really appreciate it. I have to tell you that it's the legendary Judy Stinson that got me to put on a jacket. I don't have shoes on, as many of you probably also don't, since you've been teaching from home. And some of you will recall my aversion to wearing closed-toed shoes over the years. I'm going to try to share my screen now. We'll see, because I have not been teaching by Zoom, so you have to give me some leeway here. But we'll see if this works. It is the legendary Judy Stinson, and so that is why I agreed to do this talk today. And I am so honored to have been invited to talk at the inaugural Judy Stinson Lecture. Very grateful to Judy, to ASU, to Dean Sylvester, to Associate Dean Herrera, and to ASU's extraordinary legal methods faculty for making this lecture a reality. It seemed to me when I was invited to do this that it was the ideal setting to talk about a brilliant, resilient woman, another brilliant, resilient woman, Justice Sotomayor, and the rhetoric that I'm saying is her rhetoric of settings, because she reminds us every time she writes that it's important for us never to give up. And she reminds us also of the importance of words and facts, as that is going to be part of the theme of the rest of my talk, starting with my explanation of what I mean by rhetoric, and then my explanation of what I mean by the rhetoric of settings, assuming that I can actually get the PowerPoint to advance. Some of you have seen this description before. It is my favorite description of rhetoric. It's optimistic, perhaps overly optimistic, and yet I think it's practical, and it is sort of restrained. It recognizes that the rhetorical actor first has to find or to create an opportune moment, that then the rhetorical actor has to engage in rhetoric that is appropriate. And by appropriate, what rhetoricians mean is not something that is inoffensive and not something that is politically correct, but something that can reach a responsive audience at an appropriate time. Then the rhetorician needs to suggest something which is possible. And most rhetoricians believe that what they are supposed to be suggesting is something that is aimed at achieving justice, equity, or mercy. That's the definition that I'm going to return to time and time again as I go through the rest of this talk. Late last fall, I was writing a chapter that had to do with metaphors that judges use for kairos. Kairos is the rhetorical sense of time that goes along with chronological time, and it basically gets at this same idea. The sense of kairos is to capture an opportune moment, to make an appropriate argument to receptive audience. I was looking at a lot of judicial opinions, both by federal and state judges, where they were using metaphors either for the concept that this is the right time, or for the concept that this is the essential claim to make at this particular time. And when I finished with this study, it seemed to me that Sotomayor was the person who was most suited to framing rhetorical settings that provided memorable images for her arguments. And so my claims today are these three: that you need to come up with rhetorical settings in order to provide memorable images of time and place, because those images will make your claims seem opportune, appropriate, and possible, going back to my description of the kind of rhetoric that we want to be engaged in. Justice Sotomayor is an artist at envisioning and depicting settings, and she's such an artist because she's willing to grapple with the facts and because she's so sensitive to language use. And third, when it comes to rhetorical settings, there's more than one audience. Lots of audiences count. Different audiences count for different purposes. I know that it's risky to use a piece of art as a comparison with rhetorical actors, but it seemed to me that this particular image was particularly memorable. And if I'm talking about memorable images, I thought I would use this one. This is a painting by Francisco Goya called The 3rd of May, 1808. It was painted around 1814 to commemorate the aftermath of an uprising by Spanish workers during the period when the French were occupying Spain. It certainly does qualify as memorable. I believe the firing squad over on your right, I guess, as well as my right, the light highlighting the resistor's pose, the line of other resistors waiting to be shot, the previous victims on the ground. In style, in substance, and in content, this painting was thought to be revolutionary. It wasn't shown in public for many years, even though it was commissioned by the Spanish king after the French had been thrown out of Spain. I use it not only to illustrate the idea of a memorable image, but also to try to illustrate the idea that there are a number of different settings that you might use for your claim. Before I talk about these settings, I do want to also say that this is not a Dewey Decimal system of settings. These are slippery and they shift around from time to time. And some of you are going to tell me that really all of the settings basically fall into category number 3. And I'll agree with you, but I also think that it's helpful to think about the different possible settings which Sotomayor's opinions illustrate, because it helps think about how you might envision and then describe a setting for a different kind of claim when it comes before you. The Goya painting, I think, illustrates a particular claim. Because I know that he went on to make a series of prints entitled The Disasters of War, I think his claim, his expressive intent in this particular painting has to do with the carnage and the horror of war in general. He's trying to remind the viewer of the failure of honor and glory in any circumstances. So I think that his setting is number 3, the time and place that embody the very essence of his claim. The long line of helpless resistors waiting to meet their fate, the faceless firing squad carrying out their orders without thinking. He might have used the outside world if he had a different kind of claim, if he wanted to perform a kind of journalistic reporting about the uprising by the Spanish that happened during the French occupation. But I don't see any sign of that in this painting. He might also have been using as a background frame the setting in which he was painting, number 2 on my list, the argument maker's world. Like a judge argues within a court, Goya at the time was an artist in the court of the Spanish king who had taken over after the French occupation. So you might think that he would paint something in which the resistors were symbols of Spanish heroism and patriotism, but again, that doesn't seem present here. I might, however, view the setting as timeless and universal because I am viewing the background frame as a member of a later audience, number 4 on my list. When I look at this painting today, whether I know anything about Bonaparte, King Ferdinand, or Goya, I take from it what I need and I understand it as a protest against mindless, faceless violence. Now, I just want to mention for a moment that when I talk about setting, I'm not talking only literally. I am talking literally. Your setting needs to take the facts that you have of time and place and use those facts to tell the reader about what is the background frame for your argument. But in addition to that, metaphorically, you need to come up with a memorable image that capsulizes, crystallizes that background setting. And that's what I think Sotomayor does so well. So we're going to switch from the firing squad execution to the death penalty cases in which Sotomayor has been dissenting, as probably you know, for many years. In the last 6 months of the Trump administration, Sotomayor's dissents began to focus on how the majority of the court was failing to attend to its own rules and procedures. In those last 6 months, the Supreme Court condoned 13 federal executions. Sotomayor called it an unprecedented breakneck timetable of executions. That's what I mean by a memorable image. First, she marshaled the facts. She gave you the facts. That was the background setting. Then she gave you a memorable image of that background setting, an unprecedented breakneck timetable of executions. The first death penalty example that I want to use here also has a rhetorical setting that includes the administration of the death penalty itself. In Glossup versus Gross, which some of you are familiar with, Sotomayor dissented on 2 grounds. Not only was the method of execution itself cruel and unusual, but the court converted this category into a conditional one. The method of execution was intolerably painful, even to the point of being the chemical equivalent of burning alive, but the court also held that the death penalty prisoner had to show that there was a known and available alternative method of execution to be able to show a violation of the Constitution. In this case, she demonstrated her penchant for using language well, burning alive, but she also demonstrated her ability to marshal the facts. She goes into excruciating detail about what happens when different kinds of execution methods are used in order to give you the background for the rhetorical setting that is then captured in this memorable image of burning alive. So this example, I think, is an example of rhetorical setting that has both the essence of the claim, the time and place where the death penalty is carried out, and also the setting in which she is talking, the court itself. So she's objecting on both of those grounds to this particular method of execution. In the next two examples, she's basically making the argument that against the background setting of the court itself. In Bucklew, she dissents, saying she's especially troubled by the majority's statement that last-minute stays should be the extreme exception, saying that the court basically is claiming that the most important thing is to have executions run on time. This is the rhetorical setting that she is framing here is one in which the court itself thinks the important thing is to have the process run quickly. She says that leaves you with a rhetorical setting in which the court itself has a stain that will never come out. In U.S. versus Higgs, which was the last of the 13 federal executions that took place during this 6-month period, which Justice Sotomayor characterized as an expedited spree of executions, she concluded that this is not justice. Some of you may have read this. After waiting almost 2 decades to resume federal executions, the government should have proceeded with some measure of restraint to ensure it did so lawfully. When it did not, this court should have. It has not. Because the court continues this pattern, I dissent. So in this case, she's making an argument that the petitioners should have had a chance to make their credible claims, but because of the background setting at the court, setting this argument against the background of the place where she is arguing, they were not able to. The time is rushed, and the court is and the government are both acting in an unrestrained and potentially unlawful manner. The next group of cases that I wanted to talk about all have to do with the Fourth Amendment. Some of them have to do with surveillance. Some of them have to do with police encounters, citizen encounters with police. And all of them seem to me to be describing rhetorical settings that support Devin Carbato's conclusion in this law review article. That after African Americans often experience the Fourth Amendment as a system of surveillance, social control, and violence, not as a constitutional boundary that protects them from unreasonable searches and seizures. Many of you will remember, or maybe all of you will remember, her concurrence in U.S. versus Jones. The rhetorical setting that she conveys here, the image of that rhetorical setting, is one of permeating police surveillance. And this is an example of a future rhetorical setting. She doesn't say that this is happening in U.S. v. Jones itself. She says this is what's going to happen in the future because of technological advances, technological possibilities. You may recall that in Jones itself, the court, with opinion written by Justice Scalia, with which she agreed, found that there was a Fourth Amendment violation because a GPS machine had been installed within the car that the defendant was driving. So they were able to fall back on the old physical trespass rule. But Justice Sotomayor said in the future, they are going to be able to do this kind of surveillance without having to do a physical intrusion. The problem with that is what's going to happen when you have that kind of permeating police surveillance. And she sketches the facts of that rhetorical setting in this excerpt. GPS monitoring generates precise, comprehensive record of a person's public movements. That reflects a wealth of detail about the person's political, professional, religious, and sexual associations. And she gives a list of things that would be known to the police: trips to the psychiatrist, the plastic surgeon, and so on. The union meeting, the mosque, the synagogue, the gay bar, and on and on. And these would be records that would be available to the government for years into the future. If this were to occur, she says, this kind of permeating police surveillance would undermine the relationship between citizens and their government. So this is a future setting, which she is predicting is going to occur because of technological advances. She also predicts in US versus Jones in the concurrence that the court is going to have to adopt one of three rules then before it in order to try to counter this kind of Fourth Amendment violation, that it's not going to be able to rely on trespass, and it's not going to be able to rely on the rule that when you make things available to the public, they are therefore not private and you can't protect them. So her argument here is that eventually the court is going to have to adopt again or use again the balancing test that it used originally in the Katz case. So in this case, she marshals her facts. She comes up with an image of permeating police surveillance as the background setting for her argument that the court eventually is going to have to adopt a particular test. I'll just note, by the way, that these are not always images that are brand new to her. This particular image came from a prior case, but she adopts them after going through, and all of these examples in the rhetorical setting of the facts come from prior cases. She marshals those facts. She comes up with the image, she puts them together, and she leaves you with a memorable rhetorical setting that serves as the background for her argument. That brings me to another dissent that many of you will remember, her dissent in Utah versus Stripe. In this case, the image for the rhetorical setting that she's positing, and it's not a potential future one so much as a present one, is an image of a potential police state. In Strife, the defendant was stopped shortly after he left a house where police suspected drug activity. Only after the stop did the officer learn that he had an outstanding warrant. He was arrested and a search found illegal drugs. Although the original detention was without reasonable suspicion, the court relied on the so-called attenuation exception to the exclusion of the evidence against him. In the oral argument, Justice Sotomayor's first question was, if we announce your rule saying that this is okay, even if you didn't know about the warrant, but it's okay because there was a warrant. If we announce your rule, what stops us from becoming a police state and just having the police stand on the corner down here and stop every person, ask them for identification, put it through, and if a warrant comes up, searching them? The lawyer on that side responded that the officer can't count on finding a warrant. Justice Sotomayor's response, if you have a town like Ferguson, where 80% of the residents have minor traffic warrants out, there may be a very good incentive for just standing on the street corner and asking every citizen, give me your ID, let me see your name, and let me hope because I have an 80% chance that you're going to have a warrant. Again, she marshals the facts to put together the rhetorical setting, to frame her argument that the opinion basically invites the police to make illegal investigatory stops, and the result is far-reaching and outrageous indignities and intrusions. She goes into a great deal of detail about the indignity of the stop, the intrusion of the search, how the officer's control does not end with the stop and the search, how even if you are innocent, you have an arrest warrant, an arrest record, and you experience the civil death of discrimination, how this is not isolated. There are enormous numbers of outstanding warrants, and it's often routine policy of police departments to do exactly this. And then she has an entire section about how it is no secret that people of color are disproportionate victims of this type of scrutiny. As an example of her marshaling of the facts, I'll just give you a couple of examples again where she's citing other cases. She says, the indignity of a stop is not limited to an officer telling you that you look like a criminal. The officer may next ask for your consent to inspect your bag. Regardless of your answer, he may order you to stand helpless, perhaps facing a wall, with your hands raised. If the officer thinks you might be dangerous, he may then frisk you for weapons. This involves more than just a pat down. As onlookers pass by, the officer may feel with sensitive fingers every portion of your body. A thorough search may be made of your arms and armpits, waistline and back, the groin and area about the testicles, an entire surface of the legs down to the feet. The officer's control over you does not end with a stop. If the officer chooses, he may handcuff you and take you to jail for doing nothing more than speeding, jaywalking, or driving your truck with your 3-year-old son and your 5-year-old daughter. At the jail, he can fingerprint you, swab DNA from the inside of your mouth, and force you to shower with a delousing agent while you lift your tongue, hold out your arms, turn around, and lift your genitals. And of course, if you fail to pay bail or appear for court, a judge will issue a warrant to render you arrestable on site in the future. In addition to these 2 pictures of surveillance in Jones and the period after surveillance, when the citizen is subject to stop and search, Justice Sotomayor has a couple of opinions I wanted to highlight that have to do with what happens in police-citizens encounters that end up being qualified immunity lawsuits. The rhetorical settings here that I want to highlight are how she marshals additional facts that make you, or hopefully an audience, think differently about who you believe and what you believe in these police-citizen encounters. Her views of the settings were very different in both of these cases from those of most of the other justices. In Mullinex, Sotomayor was the only dissenter from a per curiam opinion that summarily reversed the denial of qualified immunity for a Texas state trooper. The trooper was sued by Israel Leha's family for violating the Fourth Amendment by using excessive force when he shot and killed Leha during a high-speed chase. In the portion of the opinion of the dissent before this, Sotomayor wrote, Mullinex fired 6 rounds in the dark at a car traveling 85 miles an hour. He did so without any training in that tactic, against the weight order of his superior officer, and less than a second before the car hit spike strips. Mullinex's rogue conduct killed the driver because it was clearly established under the Fourth Amendment that an officer in Mullinex's position should not have fired the shots. I dissent. Then she wrote the part of the opinion I've highlighted on the slide, filling in a part of the rhetorical setting not considered by the other justices. When Mullinex confronted his superior officer after the shooting, his first words were, "How's that for proactive?" Apparently, he had been disciplined earlier the same day for not being proactive enough. Although not part of the legal analysis, Sotomayor says, this comment seems to me revealing of the culture this court's decision supports when it calls it reasonable to use deadly force for no discernible gain and over a supervisor's express order to stand by. By sanctioning a shoot first, think later approach, the court renders the protections of the Fourth Amendment hollow. Again, what I think she's doing here is she's marshaling additional facts so that the rhetorical setting of this police encounter is you end up with a rhetorical setting that is fleshed out in a way that is not usual in the court setting and is fleshed out in a way that helps you understand that perhaps, especially in this circumstance, the police officer's stated rationale, I thought I could stop him, might not have been his actual rationale. In this case, and in Salazar Limon v. Houston, Sotomayor reminds the court that in these kinds of qualified immunity cases, you are supposed to take the facts as the plaintiff stated them and to look at them at least until you get past the summary judgment stage as if they are true. In Salazar Limon versus Houston, a Houston police officer shot Ricardo Salazar Limon in the back. Salazar Limon claimed the officer shot him as he tried to walk away. The officer claimed that Salazar Limon turned toward him and reached for his waistband as if for a gun before the officer fired. The district court and the Fifth Circuit both gave summary judgment to the officer because of qualified immunity. Sotomayor dissents, saying, basically, you've got 2 different versions here. Police officer claims the victim took some act that would have justified the force. The victim claims he did not. Summary judgment is improper in those circumstances. It's possible Salazar Limon did something that Thompson found threatening. It's also possible that Thompson shot an unarmed man in the back. What is clear is that our legal system does not entrust this to a judge faced with competing affidavits. Again, she reminds the court that this is not the kind of case that is supposed to be decided on summary judgment. And again, she provides in a footnote more of the rhetorical setting. She says, some commentators have observed the increasing frequency of incidents in which unarmed men allegedly reach for empty waistbands when facing armed officers. She cites an article reporting that nearly half of the individuals shot by Los Angeles police after allegedly reaching for their waistbands turned out to be unarmed, and says, since this is increasingly common, the lower courts confronted with such inconsistencies should let the juries decide. If, as I'm claiming, Sotomayor is doing such a wonderful job with these rhetorical settings, why are all of these dissents? Why is she not winning more often? That's because sometimes the majority is just against you. So my contention is that in different audiences, she is winning, and she is winning over different audiences in different ways. Her rhetorical settings resonate with different audiences at different times. That her opinions have had impact beyond the Supreme Court and in the Supreme Court, and she's had waves of influences that go beyond the courts and into the public. The Jones concurrence, as we're going to see here in a minute, did eventually prevail in Carpenter versus US, not least because the brief writers leaned heavily upon the Jones concurrence when they wrote their briefs to the Supreme Court. When I followed her strife dissent, which was called extraordinary for its breadth and intensity, I found that her opinion had opened the door for many to think about otherwise unaddressed issues, had generated lots of discussion, and had given lawyers and courts an opportunity to cite Supreme Court authority, even though it was in dissent, for propositions they might otherwise have had a lot of difficulty supporting. For example, it is extremely rare for the justices, other than Justice Sotomayor, to refer to race or racism. So her references in the strife dissent to the talk that African-American parents have with their children about their interactions with police, her statement that people of color are disproportionate victims of police scrutiny, and her citations to books, studies, and articles recounting the experience of people of color are often the only available words from the Supreme Court about the impact of race on policing. So if you want to be able to cite anything from the Supreme Court about the impact of race on policing and the judicial system, you often are going to have to turn to one of the opinions, even if they are dissents from Justice Sotomayor. I found that lower courts cited the dissent when they rejected investigatory stops in targeted neighborhoods, when they discussed the treatment of citizens of particular neighborhoods as second-class citizens, and when they declined to decide that the mere existence of a warrant, when the officer never learns about it, excuses the officer's unconstitutional search. To name just a few, I found courts in Connecticut, Florida, Iowa, Pennsylvania, South Carolina, and California had cited the dissent for descriptions of the dehumanizing and degrading nature of police stops, and even for the number of outstanding warrants in a jurisdiction. So the strife dissent gave not only facts but citations to articles and books that contained facts and opinions that were not available elsewhere. As of early March, there were more than 250 references to the strife dissent in the Lexis News files, ranging from newspapers to newswires. There were references to the dissent in more than 200 law reviews and 13 treatises, in about 140 briefs and pleadings, and in more than 50 federal and state opinions. Nearly 80% of the 250 citations to strife in law reviews mentioned the dissent, most referring to her comments on the disproportionate impact on people of color, her references to the talk, and her citations to the number of outstanding warrants. Just backing up the influence of the Jones concurrence in particular. I'm just briefly going to mention the Carpenter case, which I think a number of you also know about. This is where the cell site location data was found to violate privacy principles and be a Fourth Amendment violation. And Chief Justice Roberts wrote this decision relying heavily on the Sotomayor Jones concurrence and the Alito concurrence in Jones. Alito, however, dissented in Carpenter on some statutory grounds that are really not important to my point at the moment. Probably. One of the things that Chief Justice Roberts now does is to come up with a resting image, I think, for the rhetorical setting when you have this cell site location data available. He says it's as if when the government tracks the location of a cell phone, it achieves near perfect surveillance as if it had attached an ankle monitor to the phone's user. The other thing he says is that whoever the suspect turns out to be, he has effectively been tailed every moment of every day for 5 years, which of course you can't really have a person tail somebody that long for that long, that pervasively for that long. But with this kind of data availability, you can. After Carpenter, you might think that there would be a let up in this kind of surveillance. But in Baltimore, in a secret, at first, aerial surveillance program coordinated by the Baltimore Police Department, planes were flying over the city, but only part of the city. This was first revealed in 2016, abandoned because it was secret and thought to be, therefore, a bad thing, obviously, and eventually restarted in 2020. The 2020 authorization was for the planes to fly for 6 months over a 32 square mile portion of the city, a portion deemed to include the city's most troubled areas because they were the site of 80% of the city's gun homicides. In November 2020, a majority of the Fourth Circuit said the program did not violate constitutional provisions because there were certain restrictions on the planes and the footage they collected. But as you see in the excerpt on the slide, Chief Judge Gregory dissented from the decision, pointing out that this really is the culmination of those earlier surveillance cases. This case presents a long anticipated Fourth Amendment question. Does the Constitution allow warrantless dragnet surveillance by the police of the sky above an American city, warrantless aerial surveillance of an entire city without a warrant, without anybody in the judiciary taking a look at it? And he quotes Chief Justice Roberts saying that the program means that for every single resident of Baltimore, whoever the suspect turns out to be, they have effectively been tailed every moment of every day. After the November decision with the Gregory dissent, the Fourth Circuit agreed to en banc review. And I think that was just maybe 10 days ago. As far as I know, there's been no actual review yet. So to sum up, my theory is that the rhetorical setting that you use as the background frame for your argument should capture and convey a lasting image of time and place, literal time and place, literal setting. But the image metaphorically should be the kind of image that capsulizes and crystallizes the essence of your argument, so that your argument itself becomes opportune, appropriate, and possible. How do you become the kind of rhetorical actor who can envision and depict such an image? Why is Justice Sotomayor so good at this? The first thing, and this sort of surprised me, that I decided after reading all these opinions and a number of other opinions, because she's written many opinions, which I think do the same thing, but I wanted to cull it down to a more manageable number. The first thing, I think you have to be open to gathering the facts, because one of the things Sotomayor does is she gathers the facts, she goes through them, she delves into them, and she's not afraid to get into the really ugly nitty gritty of the facts. I thought, especially in the death penalty cases, she goes through the facts in such detail and such care and fastidiousness that it's the setting. You are absolutely sure that the setting that she's giving you is accurate, complete, and comprehensive. Then, as for the memorable image that conveys the essence of those facts, that gives you something to remember, the thing like burning alive, the thing like contamination, which she uses in an immigration case to sum up what happened in the decision-making process. Those memorable images, I think, come from her sensitivity to language, which is shown in a number of her opinions. I also think her, and this won't surprise anybody, but it's her life experiences across the board have given her a richer and deeper breadth of experience. But part of that is her work as a trial judge and a prosecutor. She knows both the operations of the judicial system and many of its flaws. Like the other justices, she recognizes that she speaks for many purposes and to many different audiences. In an interview, she acknowledged that some of the time she's just trying to open up her colleagues to thinking about different issues. Sometimes she wants broader public discussion of those issues. She acknowledges that the voice of a justice gets lots of attention, and she believes it makes people think. So some of the time when she makes those statements, she's not speaking to the other justices. I guess that's clear. She's trying to get the people or the prosecutors or the general public or state legislatures or federal legislatures to think about issues. She's driven by the idea of equitable process, and I think that's why a number of the rhetorical settings that she conveys, especially in cases such as the death penalty appeals, in cases like the immigration cases, have to do with procedure. As she said in an interview in 2014, I can't control the outcome of cases. Law, precedent, losing the majority are reasons why I can't control the outcomes. I can live with that if I perceive the process to be fair. Has someone been given a fair chance within the legal system? I think that's one of the reasons so many of her rhetorical settings, she's not in the majority. So many of her rhetorical settings have to do with depicting the setting in the court that she's in, or in the government, the setting in which the government, whatever that government is, made that decision, or the setting in which the police made that decision. She also looks to the future, and I think that's part and parcel of grounding her opinions in the record and in the facts, because that means that she considers the future ramifications of the court's opinions. As for amplifying rhetorical settings or amplifying rhetoric, as you probably know, I'm a big believer in rhetoric, but I'm not Justice Sotomayor, so my voice doesn't go very far. And I wanted to take a moment to thank the Judy Stinson Lecture and ASU for inspiring me, because of this lecture, to amplify my own voice by making some matching contributions in honor of several remarkable women to organizations that are using rhetoric and other things to pursue the possible. Many, many organizations are doing great work towards justice, equity, and mercy. And I was inspired by reading Justice Sotomayor's opinions, and also by just thinking about this lecture and thinking about Judy to make those donations. So I wanted to thank the lecture again, Judy and ASU. Now, finally, Judy Stinson goes on the road. And boy, did she get a nice car as a parting gift. All you really need to know about, about Judy Stinson, that's not her real car. And it's so weird to not have an audience react. All you really need to know about Judy Stinson is that the legal methods faculty at ASU, at the institution, at the instigation of Tamara Herrera, unanimously agreed that she should be honored with a lecture series, and that ASU immediately made that happen. This is such a fitting tribute to Judy and to the legal methods faculty, and that's the reason I'm so delighted to be part of this event. As for me personally, I've missed gatherings of friends. I've really missed seeing so many of you. Anybody who's lucky enough to have dinner with Judy Stinson will never forget their good fortune. She's the perfect dinner companion. Anybody who's been lucky enough to sit around with Judy and a table full of friends at the end of a long day of conference sessions will always be grateful because she's an exceptionally kind and generous ally. The last time I gave a talk at ASU, a group of very, very, very convivial people gathered in Judy's office afterward. And if I could have just one wish today, it would be that all of us, every single one of us, could gather in Judy's office after this talk to share stories and commiserate and laugh. So I brought along my glass just in case. Thank you to Judy's colleagues at ASU for making this lecture possible. Here's to you, Judy, a treasured colleague and friend, and now my fellow Emerita. Thank you.
Thank you, Linda.
And now I will stop share, hopefully. Yay. Thank you, everybody.
I bring us all back. I said I wasn't going to cry in the beginning part of this before you guys all logged on for the webinar, and I just did. So thank you, Linda. You always make us think about things in such different and ways I hadn't thought about them before. If you still have time for a few questions, we have about 10 minutes or so. Would that be okay?
Sure.
Let me see what's going on. We have a couple of questions, it looks like, here in our Q&A. So if you have one, please type it in that box. Here's the first question. This is from our friend Kathy Stanchi. It says, I noticed that many of your examples are from separate opinions. Do you notice that Sotomayor does this mainly in separate opinions, or does she do it also in her majority opinions? And if it's a phenomenon of separate opinions, do you have a thought about why?
I think it's separate dissents and concurrences. Yeah, I do think it's a phenomenon of those. My guess is it's those where she feels the need to speak to future audiences. I think that's why it's more important to come up with those memorable images. I also think it's where she can talk for herself and not need to get buy-in from others. And so maybe that's, in Strife, I think she had nobody, well, somebody joined her in part of it, but in the part that is often cited, it's just her. So I think it's both of those things. But I haven't actually, I just didn't see any other than they're not even concurrences very often. But yeah, I didn't see any, I didn't notice this in any majority opinions.
Thank you. Lots of crying along with us in the question and answer, so I appreciate that. Thank you, friends. Next question from our friend Kirsten Davis. I'm curious about whether Justice Sotomayor alters the circumference of her settings depending on her goals. Did you notice that, and to what effect?
So the big difference that I noticed, and again, I have to emphasize that I don't think this is a science of categories of settings, but it seemed to me that when she's arguing about the setting in which she is making the argument, when she's arguing about the court, that's when she has a procedural argument. When she's arguing about the parties before the court, that's when she's arguing about the essence of what happened, or the essence of the time and place in which these parties were aggrieved. But I do think, like the Jones case, she was definitely, her goal was to anticipate the future. So in that case, I think that the setting was the future. I can't remember if I thought that there was one where she went for the larger culture, and it was, and again, this is really slippery, but I thought the one where, well, this isn't in the presentation. There's a couple of immigration cases where I thought she was really talking about the larger culture, the larger cultural historical background. But the answer is yes. It depends on her purpose and who she's, I think, what she's trying to do, who she's trying to reach.
Thank you. We have one more question that has popped up. What's your personal practice for using persuasion in your speaking technique, like in how you prepare for, say, for today?
I hate Zoom. Can I say? So I found it, so I haven't been teaching by Zoom. So I just found it really, really hard to try to figure out how I was going to convey all this information and put keywords on the PowerPoint and also say all the words that were so important at the same time. And so I would have to say that I am still working on that. I do not feel like I have perfected the persuasion speaking technique.
I wish I was I wish I was as far along with you, and it's sad to say I've been teaching over Zoom since last spring. So I don't think that says much about me. I'm just checking to make sure we don't have any more last minute questions before we call our lecture to an end. Lots of I miss you. We hope to see each other soon. But I see no other questions. So if I see no other questions, I think we made it within our time frame. We can all toast what we have in front of us. I happen to have iced tea because I was eating lunch right before. Oh, way to go, Judy. I didn't get the memo about the props. I suppose I should have been the one sending the memo out about the props. But thank you to everyone who attended. We really appreciate all of your interest and all of your questions and your attention. And thank you to Linda for such a wonderful and engaging speech. And thank you, Judy, for being willing to even be on camera. I know that you may have preferred that we did it a different way. And I think this worked really well. And I appreciate everybody's part.
Thank you to
making this happen.
Thank you for doing all the logistics and everything and for having the idea. So thank you. Thank you.
It's a group idea. Truthfully, we had this idea as a group many years ago.
Okay.
Sometimes you have to be pushed to the brink of things. The thing I called the Judy Cliff, right? The retirement before you actually make the vision happen. But it's good to know that we as a group can make it happen when we try. So thank you, everybody. I hope you all have a wonderful rest of your day.
You too.
Thank you. Thank you all. Great talk, Linda.
Bye all.